And we are live. It is January 25th, 2024, 4 o'clock p.m. The sirens that are going by the Mar-a-Lago bathroom studio are they're coming to take me away, I'm afraid. But that will not deter us. Joining me from Salon G of her palatial mansion is Anna Bauer. Anna, what is Salon G?
Salon G is, when I was building my palatial mansion, I thought, why not include a soulless corporate conference room? And so Salon G was born. Uh, so it's my soulless corporate conference room, Salon G.
Yeah. And Roger, which room are you joining us from?
I'm in my very finely appointed with a tiny room with beautiful moldings.
Good moldings, yeah.
But not big enough for a desk or even a chair. So I'm going to stay on the bed of this beautiful room.
Excellent.
Mansion.
It is important to have large beds in your palatial mansion to broadcast from. All of that is just by way of saying that nothing, not sirens, not being caught in soulless corporate hotels, or being stuck in bed will stop us from bringing you this week's Trump Trials and Tribulations. And we're going to get right into it with Section 3 of the 14th Amendment, because Roger has had quite a Section 3 week. Roger, first of all, bring us up to date before we get to what Judge Ludig has called your amicus brief.
Okay. So the big enchilada remains the Colorado case. We're rushing forward to the February 8th argument before the Supreme Court. That's the case where the Colorado State Supreme Court did disqualify Trump from the ballot. And so last Thursday, but too late for us to mention it on here, Trump filed his merits brief. He switched one of his arguments, which is fine. The question presented for cert purposes is very broad. He dropped. He was going to argue about this being a non-justiciable political question. That's not a very strong argument. He dropped that, and he'll bring up the argument that Section 3 of the 14th Amendment is not self-executing. You need a congressional enabling legislation. That's basically the 1869 case called Griffin's case that decided by then Chief Justice Salmon Chase, acting as a circuit judge. So then on January 31st, which is next Wednesday, we'll get the challengers' merits brief and all of the amicus briefs supporting the challengers. So that's where that one stands. And it's beginning to look like we aren't going to have many other rulings before the Supreme Court rules. In Maine, you remember that the Secretary of State, Shenna Bellows, back on, I think, December 28th, she disqualified Trump, but that then was appealed to the Superior Court. The Superior Court sent it back to her saying, let's wait and see what the Supreme Court does. We'll have, doubtless it will address some of these questions. She and the challengers tried to appeal anyway to the state Supreme Court. State Supreme Court said, no, it's now become an interlocutory appeal over which we don't have jurisdiction. So the main thing is back at the Secretary of State's office until after the Supreme Court rules. Massachusetts, there was an administrative challenge there, but the commission that handles such things, I think it's something like the State Ballot Law Commission, or dismissed on grounds relating to the fact that it was a primary. It's sort of analogous to what Minnesota and Michigan did, that basically they really have no say in a primary. You can come back because it's run by the state's political party. You can come back to us when it becomes a general election issue. Illinois, there's an administrative proceeding there. There's supposed to be a public hearing tomorrow. I think it's actually going to all be handled by stipulation. They're going to put in documents, basically documents from the Colorado case. And they're supposed to be, they're the administrative board, I think it's called the electoral board, is supposed to rule by January 30th. So possibly we'll have something from them. I think those are the main cases.
So basically at this point, are we really, all the action is in the federal Supreme Court, right? Does anything that anybody else does in the meantime matter?
I don't think so. I can't, there's so many of these things, but a number of cases, like in Oregon, in Maine, Oregon, I know that our readers don't like it when I say Oregon. They're all saying, let's just let the Supreme Court rule, and then we'll see what's next.
All right. Speaking of courts that we're waiting for, what's up with the DC Circuit?
And did you want me to address my amicus brief?
I do, but let's deal with the DC Circuit first, because we're in the land of talking about waiting for courts, and as long as we're talking about waiting for courts, we may as well deal with the DC Circuit.
So the DC Circuit has still not ruled on the presidential immunity claim.
Don't they know that I said it would be 48 hours? It's almost like they're like they don't care.
Yeah, it's been 16 days. So you're close, and counting, unfortunately. More importantly, it's been 49 days since December 7th, which is when Trump took the appeal from Chutkan's ruling, Judge Chutkan's ruling. And so that's when the automatic stay took effect. So, and what Judge Chutkan has told us, actually last Thursday, in an order, is that she implied that she initially wanted to give Trump 7 months time to prepare, and she wants to stick to that. And since he's not supposed to be burdened with trial preparation during this period, she plans to give him 7 months. And what that means, if my calculations are right, is that it could not possibly start before April 22nd. But even that is probably too early, because I haven't factored in, once the DC Circuit rules, there will be either an attempt to move for petition for rehearing of the panel, petition for rehearing en banc, certainly a petition for cert. There will be efforts to stay it while those are happening. I don't know if those will succeed. So we're talking about an increasingly worrisome amount of delay here. And in fact, as Kyle Cheney, our friend Kyle Cheney at Politico reported this week, Judge Chutkan has actually scheduled another trial for April 2nd. It's a jury trial in a case of a defendant, a January 6th defendant. Those cases don't usually last very long. But it is a jury trial, so imagine maybe 3 days, 4 days. It's a 9-count indictment, 6 felonies. So clearly that March 4th date is not operational.
All right. Let's talk about your piece that ran, I believe, yesterday morning and has caused quite a stir. This is a piece about what Justice Scalia and Alexander Hamilton thought about whether the president was an officer of the United States. Break it down a little. What is the significance of this question, and what did you find when you looked into it?
Okay. And I recommend people read the article because, like all things Section 3, it's gnarly, it's complicated, and the safest thing is to read that. Also, a lot of what I say there, a number of things I learned from reading another article, which I recommend you read. It's by a guy named James Heilpern and Michael T. Worley, and it's cited in my article. So, the way things are shaping up, I think the most important argument for Trump and those who hope that Section 3 does not derail his candidacy is the argument that Section 3 doesn't apply to presidents. And specifically, the argument, the most important argument there is that the president is not an officer of the United States. And you remember Section 3, it doesn't ban all insurrectionists from holding all offices. It bans only a special category of insurrectionists from holding some offices. And the special category is those that take an oath to support the Constitution in the process of becoming certain things. And one of those things is officer of the United States. So if the president, it doesn't count as an officer of the United States, it's game over. Trump is home free. Doesn't matter if he engaged in insurrection. And of course, that is what the district judge in the trial judge in the Colorado case held. He did engage in insurrection, but Section 3 didn't apply to him. The state Supreme Court then reversed on the law, said Section 3 does apply, and as a result, he is disqualified. So the key, the most important champions of that argument that the president is not an officer of the United States are Seth Barrett Tillman and Josh Blackman. They've been making the argument for many years, from before January 6th. The argument focuses on their interpretation of the appointments clause of the Constitution. And to cut this a little short, basically they feel that the appointments clause requires, it means that the president, only officers of the United States are people appointed by the president. And there's actually a provision in the appointments clause that is sort of a proviso that says, we're not talking about posts herein otherwise provided for. And you don't usually hear that language. I'm sorry, I don't have the exact language in front of me. Anyway, Tillman and Blackman disregard that language. It's irrelevant. It has nothing to do with anything. What Scalia said in a 2014 concurrence was, it implied that you could be an officer of the United States without being appointed by the president if your post is created in another provision of the Constitution, which is what that 8-word proviso seems to say to me. And Tillman was obviously, he recognized this conflicted with his whole theory. And so he wrote to Scalia and said, what do you mean by this first sentence where you say there can be officers of the United States that aren't appointed by the president? And he writes back. Everyone's shocked. They didn't think he would really write back. He writes back a short note, says, I meant exactly what I mean. For instance, president, vice president, president of the Senate pro tempore, Speaker of the House. Those are positions identified, set up in the Constitution. Anyway, so this means, and Tillman and Blackman basically acknowledge it means Scalia was saying the president is an officer of the United States. And their answer is they take the position that he got it wrong. Yeah, they write in a law review article, well, even Homer nods, he got it wrong. And they point instead to something he wrote 40 years earlier in 1974 when he was at the Justice Department, head of OLC, Office of Legal Counsel, which cuts the other way. Usually, of course, in my view, you would consider what somebody says when they are a justice of the Supreme Court in a formal Supreme Court ruling with the benefit of 4 additional decades of scholarship and judicial experience. That would be the more mature view of encapsulation of their view on this subject. Anyway, so this was news to me. I think it's news to a lot of people, even though it's not a scoop. It's been there in the bowels of certain law libraries for a long time. But
and Tillman has included it in his tomes on the subject, right? He's referred to it.
Yes, in fact, that's where, and if you go, you can see the note, you can see a little, he's been transparent about it. He has not mentioned it in his amicus brief. He does not even mention the 8 words proviso that I'm talking about in his amicus brief. Of course, amicus briefs, you're limited in space and time, and you are a limit, there's a page limit. So that could be, that's that. But anyway, I thought it was interesting. And the other thing they say about in criticizing what Scalia is doing is they say, well, the appointments clause says that proviso I'm talking, it says something to the effect that other than appointments otherwise herein provided for. And they're saying appointments. So what did Scalia think? That the president is appointed? And so they're asking this pointedly, like, that's absurd. Obviously, the president isn't appointed. And that's where this other article comes in by James Heilpern and Michael Worley. And they do research, including something called corpus linguistics research, where you use computers to search databases to find out how words were used at certain times in our history. You look up legal documents, look up newspapers, and they found that looking in the 1780s, that the words in both formal and colloquial contexts, that the words appointment and election were used interchangeably at that time. And they actually found James Madison, during the constitutional conventions of 1788, talking about should we have the president appointed by the entire population, or should we have the president appointed by, in effect, an electoral college? And in both cases, he says appoint, not election. And anyway, it's not the only example. There's other examples from George Washington and John Adams. He actually mentions the Articles of Confederation use. That's a formal context that I don't mention in my piece, but it's in his piece. In the predecessor to the Appointments Clause, Article 9 of the Articles of Confederation. It's a very impressive article they've written, I think. Obviously, Seth and Tillman and Josh Barrett do not think so. They've written some criticisms of that article. But anyway, that's the gist of my article, that both Alexander Hamilton, well, I haven't even mentioned Hamilton.
Yeah, we'll
yeah.
we'll give Hamilton a break. If you want the Hamilton stuff, you're going to have to go to the article itself. So
that's quite a teaser.
Yeah, so find out what Hamilton thought about whether the president was an officer of the United States. You can get it in Lawfare. So, Roger, what has the response been to this article, particularly from Tillman and Blackman, but from others as well?
Well, I've had Tillman. Blackman wrote a post on the Volok section of Reason. So I would look that up. I don't want to mischaracterize it.
It's almost entirely, I think I can say this without fear of mischaracterizing it, it's almost entirely focused on the appoint-elect usage issue.
That's right.
Not on the what Scalia thought issue, right?
That's right. I think that's safe. And then later, the two of them wrote another article in the same place called the Section 3 Endgame. We're in the Section 3 Endgame. It doesn't mention my article, but it mentions, you might want to read that too for their views. And then other than them, I've gotten positive reaction. Judge Ludig was very interested in it. So we'll and he wrote a Twitter thread or X thread about it. So,
all right.
Mm-hmm.
So from the high constitutional theory and the first impression understanding of Section 3 of the 14th Amendment, let's go to the tawdry divorce proceedings of the Wade family. Anna Bauer, I'm sort of joking about that, but only sort of. Bring us up to speed on what has happened since we last talked in Fulton County with this different form of disqualification motion.
Yeah, it certainly was not something that I expected when I started reporting on the criminal prosecutions of Donald Trump, that I would end up in Cobb County Superior Court divorce court. But that is where this case took me on Monday. So we have this Mike Roman motion to disqualify, which we've talked about before, but just to remind everyone, it's been alleged that there is a so-called improper romantic relationship between Special Prosecutor Nathan Wade and Fulton County District Attorney Fani Willis, and that as a result of that relationship, Fani Willis received, indirect financial benefits in the form of Nathan Wade paying for vacations. There are some bank statements in the case that were attached to a filing regarding the divorce case that seems to support the idea that potentially Nathan Wade did pay for some flights that Fonnie Willis joined him on, but it's really unclear, to what extent there might have been reimbursements for those payments, or what the nature was of those travels, and so we have this motion to disqualify. There's an ongoing divorce case involving Nathan Wade's estranged wife. Her name is Joycelyn Wade. I'm actually not sure if the pronunciation is Jocelyn or Joycelyn. It's because the spelling suggests maybe Joycelyn, but it could be pronounced Jocelyn. So sorry if I am pronouncing that incorrectly. But on Monday, we had this hearing that the judge set in that divorce case because Joycelyn Wade attempted to subpoena Fonnie Willis to sit for a deposition. And that would have been relevant to what's going on in the criminal case, because it's very likely that the questions would have related to the nature of her relationship with, or alleged relationship with Nathan Wade, and how he potentially is spending his money with respect to Fonnie Willis as a result of that alleged relationship. So the judge had to decide whether Fonnie Willis was going to sit for a deposition, and then he also was deciding whether to unseal the divorce records, which had previously been sealed as the result of a consent order. The judge ended up deciding to unseal the divorce records. He agreed with the argument made by Ashley Merchant, who is Mike Roman's counsel, who intervened and said that the case had not been properly sealed because there was never a hearing on it. So the judge undid the sealing, and those files became public. I went through them, but they did not seem to show any additional, information about any alleged financial or romantic impropriety between Fonnie Willis and Nathan Wade. And then also the judge decided that for right now, Fonnie Willis does not have to sit for a deposition in the case. Instead, there is a temporary hearing on the 31st. The judge acknowledged that, potentially Nathan Wade could sit for testimony during that hearing. And in fact, Joycelyn Wade's team has suggested that they intend to call Nathan Wade at that hearing to ask him about his conduct and his finances. Of course, all of this is, I think, incredibly unpleasant to even discuss because it involves people's personal affairs, and is not typically, in our area at Lawfare. But some of it does relate to what's going on with the Mike Roman motion to disqualify. So that is what happened earlier this week. And then today there's news that first, CNN has reported that it's expected that at the motion to disqualify hearing on February 15th, Fonnie Willis and Nathan Wade are expected to receive subpoenas to appear and testify at that hearing. And then also we learned that Donald Trump has adopted the motion to disqualify made by Mike Roman. And he also added this supplemental argument in which he pointed to the speech Fonnie Willis made at a church in Atlanta, in which she raised questions about whether there's a racial element to the response that folks have had about her hiring of Nathan Wade. So that, I think, is a good summary of what's going on the Fulton County front. There's also a hearing that was today that doesn't relate to the divorce.
Yeah, so we'll come back.
Yeah.
We'll come back to the hearing today. But so what we're expecting, just to be clear, is Wade will have to testify in the divorce proceeding, presumably about his relationship with her. She has to file a response by the 2nd, I believe, right?
Mm-hmm.
And then they have an evidentiary hearing at which both will have to testify in the criminal matter on the 15th.
Two
on the
yes.
on the disqualification question.
Yes, but two caveats to that. One is that although it's been suggested that Nathan Wade will be asked to testify at that divorce hearing on the 31st, my area of legal knowledge does not really go to family law or divorce court in Georgia. That's so I don't want to claim
Roger's
any sort
the
of
expert on divorce law in Georgia. You and I don't know anything, but he used to practice in that area.
But I will say that from speaking to family lawyers about this, it's a temporary hearing, meaning that it's a hearing that's usually about before parties have reached any kind of settlement or there's a final hearing date set in terms of, a kind of trial or proceeding about the divorce. You usually can have this temporary hearing that's kind of about the interim arrangements between the parties in the meantime. And at that hearing, the questioning is a little bit more limited in scope. So it would, be about his finances and what he should be paying in the meantime, if he does, need to be paying more to Joycelyn Wade or not, and that kind of thing. So it may be, that the scope of the questioning will be a little bit more limited than it would be in, at this evidentiary hearing on the 15th. And as to that hearing, I need to do a little bit more research on what some of the privilege or kind of prosecutorial, immunity privileges that could be raised under Georgia law in an effort to maybe have Fani Willis and Nathan Wade avoid testifying at that hearing. Of course, they could, plead the Fifth Amendment. If they or invoke the Fifth, but I think that would be something that would be unthinkable.
Hard to imagine that they could actually do that consistent with keeping their jobs.
Exactly.
But what we're sure of is that there will be a hearing on the 15th and that she will file her brief in opposition on the 2nd.
Yes, I mean, it's possible that they could file something before the 2nd, but I expect that, especially given that hearing where Nathan Wade is expected to testify is on the 31st, it seems very likely to me that maybe they will wait to see, what the scope of the questioning is on the 31st and what happens at that hearing so that they kind of can make a response that is based on all of the public facts that are out there. So I expect to see it on the 2nd.
All right. So, meanwhile, there was a hearing today on other matters. What has been going on in the court other than this little divorce court subplot?
Right. So today we had a hearing on Jeffrey Clark's motion to compel evidence. Jeffrey Clark has asked for the prosecution to turn over two categories of evidence. One is communications with White House counsel or the Biden White House that went on or seemed to have gone on during the investigation stage, during the special purpose grand jury stage of the investigation. We know this because in the billing invoices that were attached as an exhibit in the Mike Roman motion to disqualify, Nathan Wade had indicated, meetings with White House counsel or meetings in DC, like with White House, and kind of made those notes that indicated that there were these meetings. And so Jeffrey Clark's counsel saw that and said, I want any kind of communications that the Fulton County District Attorney's Office has had with the White House. The reason being that they argue that it could be the basis for a selective prosecution claim. Of course, it kind of fits in with the theme that some of these defendants have gone with in their public kind of narrative around their defense, which is that, this is some kind of coordinated effort either with the January 6th committee or the Biden administration to selectively prosecute them. So that's kind of the thinking there. And then the other category of evidence that Jeffrey Clark wants is correspondence with the federal government or the Justice Department as it relates to something called TUI requests. TUI requests are these requests that are typically required when a litigant is seeking the testimony of a current or former Justice Department official as it relates to their official duties. And typically, you have to ask for permission, basically, for them to testify as to some of those issues. And then it can be it can be authorized or it can be not authorized. Very often it is the Justice Department does not authorize that testimony. So that's kind of what is going on there, because it was reported in the New York Times that as it relates to Richard Donahue and Jeffrey Rosen, who are two of the former DOJ officials who are expected to be key witnesses as it relates to Jeffrey Clark's charges, it had been reported that those TUI requests were denied, I believe. I need to look back at that reporting, actually, but there was reporting that there were these TUI requests for their testimony. The Fulton County District Attorney's Office has, in this hearing, stated that both of these categories of evidence related to communications that were more about kind of logistics and requests for testimony as it relates to either, with former White House counsel officials. They said that the White House has a kind of TUI-like process. And then, of course, with the Justice Department, they would not really say whether the requests were granted or denied. But so that's kind of what was going on in that hearing. Judge McAfee ultimately just said, as it relates to the White House counsel stuff, if you have any documents, I'll look at it in chambers, and then I'll decide if these should be turned over under Brady versus Maryland, which is a case that requires prosecutors to turn over exculpatory material. And then he also said, as to the TUI letters question, he would look at the law on it and decide whether these letters are something that even, fall under Brady and that would need to be turned over. So we kind of left it at that. It's no real, outcome or decision that he made today, but just kind of things they're gonna work through all of that.
All right. Meanwhile, Peter Navarro has been sentenced to 4 months in jail. And I bet that the vast majority of people watching this have no memory of who Peter Navarro is or why he would be sentenced to 4 months in jail. So, Roger, give us a refresher. Who the heck is Peter Navarro, and why does anybody care that he's been sentenced to 4 months in jail?
Was a top advisor to Trump. I can't remember if he went all the way through or not, but he seemed to have information about some information about January 6th. He wrote a book later about that, and the January 6th committee subpoenaed him. And unlike Bannon or Scavino or Meadows, who were also all subpoenaed, he didn't even hire an attorney. He just said, executive privilege. No, I understand this stuff. I'm completely immune. I was a top official, executive, and I'm immune from this stuff. And it turns out it's more complicated than that. And once he was indicted, he got an attorney. But his case is really unique because no one was as arrogant as he was. And so he didn't show up at the deposition, and he didn't produce any documents. You know, there are legitimate arguments about top officials. There are even legitimate claims they might not have to testify in certain circumstances, but usually those are officials who are still officials, and those are officials who are testifying about presidents who are still presidents. And usually the person invoking the executive privilege or presidential testimony privilege is the president, not an ex-president. And in this case, he hadn't even received a letter from or anything from the president. The president had told him, relating to an earlier subpoena having something to do with COVID, not that he wanted him not to cooperate to the extent possible. But there was no communication with the president on this January 6th. So it's an extraordinary case. He was convicted, and he was given 4 months. He spoke today at his sentencing. I wasn't there. I followed some the bloggers, including Kyle again, Cheney, and he spoke against his the advice of his attorney. By the way, his attorneys include familiar names to you all: Stan Woodward, who represents Nauta, John Irving, who represents De Oliveira, Rowley, who used to represent Trump. Anyway, so they did not want him to speak. He did. He said he was sort of snide. He said, "So all of this comes down to that I didn't hire an attorney. I mean," and then he says something about something about having gone to Harvard, and I can't remember the whole phrase. It was not necessarily very helpful. And but this was the result.
Moral of the story: when you receive a congressional subpoena, do consult with counsel. Don't ignore it completely. These things can come back to bite you in the ass. And when they come back to bite you in the ass, follow the advice of your attorney that you should have hired about whether to annoy the court. All right. Let's check in on Judge Eileen Cannon, who has not had an especially busy week, but one that we should check in on. What's she been up to?
Well, we're still working on this SEPA Section 4 business, which was originally set to be settled sometime last October. She's having an ex parte proceeding with the government next Wednesday. She's going to have a 2-day hearing, February 12th through 13th. This is, I've explained before, I'll just very briefly, there's some additional materials the government thinks Trump is entitled to, classified. They want to give him some of it, but redact others, or make substitutions because it's ultra sensitive. And so, and the SEPA procedures allow for this. Usually it's done ex parte. Trump wants to be involved somehow, have his attorneys at least see the materials and help the judge decide whether some of it should be turned over, more of it should be turned over. And the judge has not yet decided on whether to give any access to Trump's attorneys. And he made a similar motion in the Washington case, and Chutkan denied it. But that's where that stands. There was an interesting thing that doesn't really relate to her, it relates to Trump. you might remember last week, I mentioned that Trump had filed, his motions to compel, and a lot of the motions to compel were blacked out, redacted. And so with the motion to compel, they filed a motion to unseal. The government responded to that, and they said, there are parts we can unseal, but we want to keep a lot of it redacted because it would reveal witnesses and this and that. The reply was sort of strange. It says, we take no position on what the government wants to do. And then the press coalition submitted a motion saying that they wanted to support basically Trump's motion to unseal. And Trump replied to the press coalition saying he opposes their motion.
Which was in support of his motion, right?
Exactly. Because they didn't provide Trump with sufficient time to meet and confer. When you file a motion, you're supposed to check with the other side to see if it's contested. And there's no limit. It has to be a reasonable effort. And so on a Friday at 2 p.m., they approached Trump, said, can you get back to us over the weekend or in any event before 11 a.m.? So the government got back to them by then. Trump didn't. Then they filed their motion. And Trump is saying, nope, that wasn't a reasonable enough time. And he's doing this with a motion that seems to support his motion. It's very odd. It could mean it's another stalling thing, or maybe they've reconsidered whether they really do want everything unsealed. But you might remember this happened with great success back in July when the government first tried to approach them July 12th with a protective order relating to SEPA materials, classified documents. And they wouldn't give a straight answer. And finally, the government the special counsel filed the motion, and Trump objected because of the lack of sufficient time to meet and confer, and Cannon agreed, and we ended up not getting a protective order in place for another 2 months. So I don't know what's happening here. It's another odd thing.
And none of these odd things that are seeming to move the ball on scheduling, right? We're still just plodding along at a pace until March, when we will revisit the May 25th trial date.
Yes, I think it's March 1st that there will be a hearing, and she will on whether to put off the trial date, and that's when presumably the formal decision will be made.
All right. Before I go to audience questions, are there any other matters we should cover? All right. Josh asks, in the context of the E. Jean Carroll defamation trial, is Alina Habba as incompetent as some reporting makes it sound? Why didn't Trump just ignore this trial? It seems not to be the best publicity for him. So these are two separate questions. And I will say that, just as a preliminary matter, none of us has been in the courtroom on this trial. And so I don't think we're in a great position to evaluate whether she is quite as incompetent as the reporting makes it sound, because we don't have the baseline of our actual judgment separate from the reporting as to what her competence level is, it does look like she really does not have a basic understanding of the rules of civil procedure in New York. And the judge has kept badgering her about that or correcting her on that. She also seems to there does seem to be a lot that she doesn't know. She is not a particularly experienced trial lawyer, and she also, in her defense, has a completely impossible client, which is to say, I don't care if your lawyer is Edward Bennett Williams, if you're sitting there making snide remarks about the judge and commenting on jurors. I mean, you're doing your own work at that point, making sure the court is as hostile to you as possible. And so I'm not, she may not be doing a great job as a lawyer, but she's got a terrible client in addition to that. So why did Trump not ignore this trial? This is an interesting question. Not sure if either of you have thoughts on this, but I will just say, I think, first of all, Trump mostly doesn't default things. There are, he does tend to be represented. He does tend to use cases to go on the offense and attack people. And he clearly thinks he gets some benefit out of the defense or his presence in the courtroom. He's not merely not ignoring it, he's showing up himself. And I assume that this is a function of his view of the benefit he gets from it in the political arena. He certainly isn't doing himself any favors in the court. Do either of you have thoughts on this?
I, like you say, I think it's as far as when a client wants to speak, you can argue with him all you want in private, but it really is ultimately his decision or her decision. And, even in criminal cases, people make that decision against what the defense lawyer recommends. And I think that actually, they got through this in a much more uneventful way than in front of Engoron, which was, of course, a bench trial. If it had careered out of control in a jury trial, I do know Judge Kaplan. I have seen him in other cases, and he is a whip smart guy with a very short fuse, and they did avert disaster in that respect. He would not have put up with much. You might remember there was a very Trump-like guy who is sort of, he's still sort of a hero to the left, named Steve Donziger. He won that 23 billion, originally $9 billion verdict in Ecuador relating to oil spills. And but it turned out that it was later adjudicated that it had been obtained through various kinds of fraud, perhaps bribery as well. And in the U.S. court, it was Kaplan, and he eventually held that guy in criminal contempt. And when the Southern District refused to decline prosecution, he appointed a private prosecutor who got a conviction in front of a different judge and sentenced him to 6 months. I think he did a lot of it in his apartment because of COVID. Anyway, this is somebody who does not really brook much foolishness. And I think they got through it. And maybe give Alina Habab some credit. Maybe she talked to him in private about who this person was. I don't know. So it wasn't the disaster it could have been. The rest seems to be calculations that are either political or have to do with personality disorders, and they're beyond my scope in either event.
Yeah, I will just say I have also watched Judge Kaplan over the years, and he is, among other things, a very fine and scholarly judge. He writes good opinions. He's a very serious guy. He is not an Eileen Cannon in his tolerance for the antics of Donald Trump. Jared asks, I know it's basically impossible under this Congress, but could Congress theoretically use its power over court jurisdiction to mandate that federal courts expedite cases involving presidents, members of Congress, or other officers when the cases pertain to activities alleged to have occurred while in office? Short answer, yeah. Mostly court management issues are left to the courts, but Congress does set up certain specialized procedures for certain types of appeals. For example, appeals under the Voting Rights Act are handled differently from appeals in other cases. Various cases get tried in front of types of 3-judge panels. So Congress could theoretically set up some procedure like this. The courts don't love it when Congress kind of micromanages them like that, and you might get some pushback. It's pretty rare for the court I can't think of an example of Congress saying privilege this type of criminal case over this type in your day-to-day case management. So I would think it wouldn't be the kind of thing that Congress would typically do, but I don't see why they couldn't do it. Any thoughts on that? All right, next question. This one is clearly for Anna. How might removing one or both of Willis or Wade from the prosecution of the Georgia RICO case affect the case? Would it cause delay, dismissal? Yeah, so assume the worst for Fani Willis and Mr. Wade. What would be the consequences for the case?
Yeah, so if they're disqualified, there is Georgia precedent that says that disqualification imputes to the district attorney's entire office. So it wouldn't just be that, Fani Willis and Nathan Wade are thrown off the case and then their deputies can continue the prosecution. It would mean that the entire office, if Fani Willis is thrown off the case, would be barred from continuing with the prosecution. But it doesn't mean that the case goes away. I have no reason to think that the alleged improper relationship or alleged improper financial benefit would lead to dismissal, although Mike Roman does have a separate argument that is about, the appointment power and whether that should lead to the dismissal. And we don't need to get into that right now, but I am a little bit skeptical that will be something taken up by Judge McAfee. But as to the disqualification, under Georgia statute, what happens if they are disqualified? Then the office is disqualified. Then it goes to the prosecuting attorney's council of Georgia. There's a guy who's the executive director of that council. His name is Pete Skandalakis, and he is the guy who will decide who should be the person who takes the case. It will be assigned to another district attorney's office, probably one that has a similar capacity and ability as the Fulton County District Attorney's Office. Andrew Fleischman, for example, has suggested that the DeKalb County prosecutor would be someone who would be an ideal candidate to take on the case. It also, though, could be the case that a private attorney is appointed to take over the case. So some things that have been thrown out by folks has been maybe John Floyd, who is currently a special prosecutor and is a RICO expert, could be appointed to take over the case because he's already worked on it. He's technically not a part of the district attorney's office because he is a special prosecutor and in private practice, or someone like Anna Cross, who is one of the other special prosecutors. I would need to look in to see if there's any like weird rules about those folks being disqualified from then being appointed once the prosecuting attorney's council gets involved. But that is just, one idea that I've seen thrown out there, which I think would be a more ideal situation if they are disqualified, because then you have at least two people or one person continuing on. All of which is to say that this is certainly, if they are disqualified, it would almost certainly lead to delay. I can't say how long. It kind of depends on the circumstances. But I will say, Bonnie Willis was disqualified from the Burt Jones investigation in the summer of last year. So over a year ago. And the prosecuting attorney's council has still not appointed anyone to take over that investigation or assigned it to a district attorney's office. So if that delay tells you anything, then it could be quite a while before there's anyone assigned. Maybe there are special circumstances there, though, and this is a bit different since it's an already indicted case. But I certainly would expect quite a delay. At this point, I'm very, very doubtful. I was already doubtful that this case would go to trial before the election, but I am especially doubtful of that now.
I will just say, if you're have a name like Scandalakis, it is almost incumbent upon you to go into the business of managing other people's scandals, and figuring out who the lawyers who should replace scandal disqualified lawyers are. Murray asks a question with Roger's name all over it. Are presidential electors in any way responsible for complying with the 14th Amendment, Section 3, either civilly or criminally? Could an election get a pre-enforcement review of potential harms they might face? Could an elector, by casting a vote in the Electoral College for Trump in violation of the 14th Amendment or acting as a faithless elector? So I take this to mean, do the electors have any responsibility under their own oath to say, hey, wait a minute, whatever, you may not be qualified to be president under the 14th Amendment? And is there any enforcement mechanism for that?
I'm pretty sure there's no enforcement mechanism for that. I'm almost certain that no one knows the answer to your first question, which is, can they, refuse to vote for the person they're bound to because of they feel that he's disqualified. The other, this is definitely something that part of what people are afraid of. Another thing they're afraid of is, regardless, if the electors do, follow their sort of their small d duty, if they vote the way their slate is supposed to be committed, then the question becomes, what happens on January 6th? Will there be objections by both houses to these votes for Trump on their view that he's disqualified? And of course, the Electoral Count Act was amended last year to change the bases that you can refuse, for which you can bring an objection. But I think it's pretty there's a very lively likelihood that congressmen could do that. And that's one reason that I mentioned that I think the argument that Section 3 doesn't apply to presidents has become such an important one. There are other ways to get rid of the Colorado case, and even other ways to get rid of all the litigation. Like if you say Section 3 isn't self-executing, or so Congress has to enact enabling legislation first. That doesn't mean he's qualified. It means no one yet is in a position to say whether he's qualified or not. And so when you get to January 6th, the congressman can say, well, we're in a position, maybe no judge is in a position, but we're in a position, and it's obvious they can say what they make the decision they want. And so, and actually, Tillman and Blackmun argue in their amicus brief. They make two arguments. One argument is Section 3 doesn't apply to presidents. The other is Section 3 is not self-executing. But they tell the court, please don't just rule on 3. I mean, on the self-executing. You really have to say that Section 3 doesn't apply, because otherwise you won't solve this problem of what happens on January 6th, 2025. Because the self-executing question leaves this open to Congress. If the court says Section 3 doesn't apply to presidents, then it does seem decided.
All right, last question from anonymous attendee regarding the 14th Amendment, Section 3. Could saying it is Congress's problem to remove any disqualification be a valid way out? At least for the SCOTUS, Congress can do what it wants. Colorado can do what it wants. States select electors in different ways already. So I've addressed this in the past. I think it does not answer the question. The Section 3 does seem to be negatively self-executing. That is, it provides for Congress to get involved to undo the disability. It does not, by its terms anyway, seem to require Congress involvement to put it in the first place. And we've had questions in the past about whether Congress could make a statement to the Supreme Court by, say, holding a vote to remove the disability. Chuck Schumer would call the Senate and have a vote. Presumably, you wouldn't get 2/3. You would therefore vote it down, and then you would have the argument before the Supreme Court. Look, Congress voted on whether to remove the disability and decided not to. I think it's a bit of a parlor trick, honestly, but it's not a bad parlor trick. And I do think that, the more attention the Supreme Court pays to the text, specifically the removal of disqualification portion of the text, the more it looks like that that the assumption is that there is a self-execution and that Congress's involvement would not be to execute, but to remove the disability that the provision imposes itself. That's my thought on this question. Roger, Anna, if either of you have others, feel free.
No, I think that does it.
All right, we are going to leave it there, folks. We will be back next week. Maybe there will be more briefs. Maybe there will be a DC Circuit ruling. Maybe Eileen Cannon will have actually done something. And we will certainly, by a week from now, I think we will probably have a brief from Fani Willis, although it might not have come in by the time we record. So we will be back then from the Ukrainian library. I'm Benjamin Wittes. From bed in some hotel room, it's Roger Parloff. And from Salon G in the Soul